Well, at 1 minute past, and I can see we're going up slowly, but just about at 250 participants. I think it will make a start. Good morning, everyone. My name is Piers Riley-Smith, and here with me today is Ruth Stockley KC. And today's webinar is looking at whether, well, the slightly provocative title of our public rights of way discriminatory. Really, what we want to examine through that is the potential tension and interrelation between the Highways Act and, in particular, highway authorities' duties in relation to public rights of way and their corresponding interrelating duties under the Equality Act 2010. But first off, as we can see from that slide, I suppose important to do introductions first, although some of you may know some of us. But collectively, me and Ruth are the King's Chambers highway team. Ruth Stockley KC probably needs no introduction, but the thing that's worth stressing, I suppose, is that she is the newest Highways Silk, a specialist silk in highways matters. She is the editor of the Highways Encyclopedia, the co-author of what I think is now called Highways Law, although I certainly know it, and I think a lot of people know it as Surveying on Highways. But she is our headline star and our leading expert today. Playing certainly second fiddle to hers, I'm Piers Riley-Smith. I'm a highways barrister as well, specialised in highways. I'm the deputy editor of the Highways Encyclopedia, and I also sit on LexisNexis's editorial board as their expert on highways. So that's us. That's who we are. Why is this important? Well, why do we think it's important, or at least certainly interesting as to what we're going to be talking about today? Well, both me and Ruth, when we sat down and sort of wanted to think of a topic to speak on, both stumbled across the fact that more and more we're being asked to advise highway authorities in particular about how they should be according with their duties under the Equality Act in relation to perhaps the and we're going to touch on all these topics, the quality of surfacing and repair of particular public rights of way, in relation to obstacles, obstructions that are there, be it lawful or unlawful, or potentially introducing structures or barriers. And the more you're asked to advise on it, and the more we looked into it, the less help we found coming from, in particular, the guidance documents, but also the lack of really any useful case law in relation to it. And so what we wanted to do is, for whatever reason, and we can't quite put our finger on it, it's becoming a more and more common topic for highway authorities to have to deal with, but we thought it was something where we couldn't find publicly available, particularly useful, comprehensive guidance on it. And so we thought that meant it would be perfect to have a webinar on. What we're going to be covering today is really three things. I'm firstly going to set out for you all the law and the guidance insofar as it exists and insofar as it's helpful. I'm then going to hand over to Ruth to hopefully usefully illustrate the application of those principles and law in three practical scenarios that we have taken, which may resonate with some attendees already, maybe something that they've been asked to consider. And so we hope in doing so, this isn't just going to be, as it were, a dry setting out of the law, but also actually applying it and seeing how we say these issues and points should be worked through. I should say that first of all, this webinar is being recorded, and the recording will be provided hopefully later on today. Also, at the same time, this PowerPoint is going to be forwarded as well. Purposefully, at least certainly in the law and guidance section, they're quite text-heavy slides. The reason for that is partly so you can all follow along today, but more importantly, so that you've got a useful written record of some of the key provisions and points. So without further ado, let's turn to look at the law and start with the Equality Act 2010. And the starting point for highway authorities is that we think there are four broad areas that you need to be aware of. Now, the gateway statutory provision for this is Section 29, which applies to people exercising a public function. And of course, people can include a local authority. Now, there is actually, and I'm afraid there are a few times during today that I'm going to highlight there are elements, grey area elements, because we've not got any sort of clear law on it. But under the Equality Act, there is a distinction made between those providing a public function and what's called service providers. Now, we've mostly approached this. We will touch on some elements of service providers, but we've mostly approached this as being that highway authorities are providing a public function rather than being a service provider, although there could be argument on both sides. The reason being, when you look at the definition of public functions that the Equality Act is talking about, when you look at the statutory code of practice, it includes things like planning services and elements like that. So we felt that a highway authority providing, as it were, and protecting the public's right to the public rights of way in their area is more akin to a public function. But anyway, because of that, through Section 29 of the 2010 Act, there are a number of requirements and duties that a highway authority must not do anything that constitutes discrimination, harassment, or victimization, a duty to make reasonable adjustments and elements like that. So we can, from 29, draw, we say, 4 elements of the Equality Act which could be relevant. The first is the one that is probably the least relevant, and that, of course, is direct discrimination. Direct discrimination is defined under Section 13 as where A discriminates against B if, because of a protected characteristic, A treats B less favourably than A treats or would treat other people. In other words, where the direct intention of the Act is to treat less favourably those with the protected characteristic. And highly unlikely that this will ever be something that a highway authority will have done. It could occasionally be the case that they are alleged to have directly discriminated against someone. And the important element there is, as we're going to come on to look at the second area, it comes to whether there is this intention to purposefully discriminate against someone with a protected characteristic. The next area of the 4, and the one we'll spend a bit more time on, is indirect discrimination. And this is defined at Section 19, where there is A discriminates against B if there is a provision, criterion, or practice which is discriminatory in relation to a relevant protected characteristic of B's. Now, again, the second grey area, which we've not been able to find anything that fully resolves, is whether a highway authority's provision of and protection of public rights of way can be considered to be a provision, criterion, or practice. However, because of the very, very broad way in which it is treated, it is a very, very large category and purposefully done so. I think it would be a very brave highway authority who said that we cannot indirectly discriminate because we are not in any of our public functions providing a provision, criterion, or practice. We think it's likely that at least one of those is triggered. So our advice is definitely consider that it is possible for a highway authority to indirectly discriminate. And when you see the terminology there, PCP, that is a reference to provision, criterion, or practice. Now, Section 19 goes on to, however, set out the 4 criteria that must be met, or the 4 elements that must be met for something to be discriminatory. And I think it's important here really to focus on the 4th, because the first 3, I think, will actually commonly occur for some elements of a highway authority's practice, and I'll illustrate that in a moment. The highway authority is doing something that would apply to persons who do not share protected characteristics, but it puts those who do have a protected characteristic at a particular disadvantage, and then that they are actually put to that disadvantage. However, the critical 4th element is, and it's there at D, that it's only indirect discrimination or discriminatory if A cannot show it to be a proportionate means of achieving a legitimate aim. So if we take an example which may, I'm sure, be picked up by Ruth when we come on to the scenarios in the latter end of this talk. If a highway authority is erecting access barriers on a public right-of-way to prevent vehicular use, that may, in fact, be discriminatory in relation to those with mobility problems, perhaps who need to use wheelchairs and cannot therefore get through the access barriers that are preventing the vehicular use. That will probably meet those first three elements, A, B, and C, given it is putting that person who has that protected characteristic and anyone who shares it at a particular disadvantage. However, the relevant question will really be whether, in doing so, the highway authority have been doing it as a proportionate means to achieve a legitimate aim. And that's something I'm sure that Ruth will pick up upon. But just as an illustration of how actually the fourth element might be the most relevant. The third of the four main areas that we think highway authorities need to be aware of is the duty to make reasonable adjustments, which again it is set out at section 20, explained at section 20, even though it's referenced and applied in section 29. And the duty to make reasonable adjustments is set out as being three requirements, but we think only the first two requirements will ever be relevant for highway authority. The first is where a provision, criterion, or practice puts a disabled person at a substantial disadvantage in relation to a relevant matter compared with someone who's not disabled, then the duty requires the authority to take such steps as is reasonable to have to take to avoid that disadvantage. The second requirement is then as to the same point, but as to physical features, where a physical feature puts a disabled person at a substantial disadvantage, then again, the duty is to take such steps as is reasonable to avoid that. And actually, section 20, subsection 9 makes clear in relation to this second requirement of the physical feature, that can include considering removing it altogether, altering it, or providing a reasonable means of avoiding it. And as we say, considering primarily a highway authority providing a public function, it is critical, and it's there at the bottom of the slide, to read this duty in light of Schedule 2, which deals with when you have services and public functions and reasonable adjustments. And one of the most important elements of that, we say, is paragraph 2 of Schedule 2, subsection 8, which notes that a key limitation to this duty is it doesn't, if, as we say the highway authority are, exercising a public function, nothing in the duty to make reasonable adjustments requires the authority to take a step which they have no power to take. Now, for the first time, I'm going to touch upon the statutory code that is produced. Important to note, in fact, that I think the statutory code is currently under consultation. I think it ends in early next year, and that may lead to a revision and a change in the statutory code. But obviously, I'm referencing and using and relying upon the one that is currently in place. And the statutory code here does provide helpful assistance as to what a reasonable step or adjustment might be. But the first point that it makes clear between 7.20 to 7.23 is that the duty to make reasonable adjustments is importantly an anticipatory one rather than a reactive one. I.e., it won't be good enough for a highway authority to say, if there is this allegation, well, no one ever complained to us about it. We've never been raised a particular point about it. It is purposefully meant to be anticipatory and owed to disabled people at large. It's also a continuing duty as well. So it's not good enough to say, for example, if we continue this illustration, well, we thought about it at the time when we put in the access barriers, and we considered that actually we'd taken all the reasonable steps. So we're not going to look at it again when 10, 20 years later, perhaps, a point or an issue is raised about them. The statutory code also provides useful, helpful assistance as to what a reasonable step is, and that's at 7.29 and 7.30. And really the point to draw out of this is that, of course, what is reasonable is a question that depends on all the circumstances of the case, including, of course, the type of service being provided. And we think this is going to be particularly relevant where you have the interrelation of the Equality Act and highway authority duties, because highway authorities have to maintain and deal with a vast network of public rights of way throughout their area. And that surely must be relevant as to how often, for example, they can, with their continuing reactive duty, be reviewing all the physical barriers within their area to consider whether or not they're complying with their duty to make reasonable adjustments. That's reflected further, in fact, in 7.30, where it highlights particular points that may be relevant as to whether a step is reasonable, the extent to which it would be practicable for the service provider to take that step. Again, we think that's going to be really relevant for highway authorities. The financial cost of doing so, and of course the extent of the service provider's other financial and other resources. So this is particularly in relation to this third of the four broad categories. This is where we think it's particularly important to stress that it is never the case for someone to simply say, again, I'm sticking with this easy example. We're going to look at other examples when we come through practical scenarios. But for someone to say, I can't get through this access barrier, you have failed your duty to make reasonable adjustments. Well, no, in fact, it is a wider judgment, fact-specific call as to that. But also important to say, the highway authority needs to deal with both of these points. It may be that the highway authority can show that it is a proportionate means of achieving a legitimate aim and therefore it's not indirect discrimination, but it doesn't mean that there isn't necessarily a step that could be taken to ensure they're meeting their duty to make reasonable adjustments. This is why we split them out into four, and they're separate, and they need to be separate consideration. The fourth area is probably the one that most people on the call are most familiar with, which is the public sector equality duty. And this is where actually we have, not the case law I'm citing on this page, the one I'm going to cite next, but we have a rare instance of where we've got very useful Court of Appeal authority as to the interrelation of public sector equality duty with highways duties. So what I've not done, given I think most people will be familiar with it, is actually quote out the Section 149 public sector equality duty. It broadly sets out a number of needs and objectives which an authority must have due regard to, and I've listed some of them there: eliminating discrimination, advancing equality of opportunity, fostering good relations. And I've also given you, as a bit of a cheat sheet, for me, it remains that the most useful summary of the principles is Mr. Justice Gilbart's in the case of Moore. Again, even going back to it's a bit dated now in 2015, 109 to 110, there is this encapsulation of the 10 relevant principles for public sector equality duty. I don't think a local authority can do much better than having review to those, but to summarize it and boil it down even further, this duty to have due regard to these objectives and needs is not a duty to achieve results. It's just that when making decisions, the authority have to be able to show that they had due regard to, considered as a matter of substance rather than form, the need to achieve these things. It doesn't mean that it has to result in the authority doing something specifically. But if I turn the page, and again, this is a text-heavy slide, but it's one which I'm more including for sort of when this PowerPoint is shared. A particularly useful application of public sector equality duty in a highways context, this is in relation to experimental traffic regulation orders, was in the case of Sheik versus Lambeth. And where, as well as usefully summarising the legal principle, this paragraph at paragraph 76 is a really nice encapsulation of the court saying, well, this is how we know you've met the public sector equality duty. You can consciously directed your own mind to the matters that you had to, you were demonstrably aware of the considerations relevant to it and was reminded of it. And the other final point I've underlined there is, of course, the due regard duty did not compel the decision maker to go behind his fellow officer's assessment. It didn't compel a certain result. Sheikh is provided there as a useful one of those four, but if I'm honest, while Ruth is going to touch on them, I think it's the first three that are the ones where we're in slightly more out of our comfort zone. I think highway authorities are mostly pretty comfortable, given it applies across them having to their functions, are more comfortable with public sector equality duty. So, turning then to dealing with where these sorts of issues are touched upon in the Highways Act. And I'm afraid to say it's pretty brief. It's pretty light touch in the way in which there are express statutory provisions dealing with equality issues. We have got Section 175A, which is the duty to have regard to the needs of disabled and blind in executing works. And given, of course, street includes any highway, this would expand to any of the public rights of way, although clearly in its wording, it's much more directed at street works. We can see into its lampposts, bollards, permanent obstructions in a street. But theoretically, this due regard to have the needs of disabled and blind people could apply. There's then a very particular reference in relation to under Section 147 and the erection of stiles and gates for controlling animal ingress and egress, and there is there a specific requirement to have regard to the needs of persons with mobility problems when you are exercising that power. That's subsection 2A. Just important to note, of course, that again, it's not compelling a result. It's just this requirement, a bit like the public sector equality duty, of having regard to, expressly considering the needs of persons with mobility problems and how this is going to affect it. And then there is this power, this discretionary power at Section 147ZA to make agreements relating to improvements for the benefits of persons with mobility problems. Again, it's tied to 147. It's not more broadly used, but it's the ability where you've got a structure which is an existing conditional limitation to the public right of way, and either the structure was there because it was there when the public right-of-way was created, so it's lawful, or it was erected under 147, well, then a highway authority can try and reach agreement with the landowner to improve it in a way that makes it more accessible. But beyond that, as far as we're aware, very limited express statutory provisions that deal with, within the Highway Act, I should say, deal with these equality issues and how they interrelate. Turning then to guidance, and I must admit our view on this is that the available guidance is not, this was partly, as I said, one of the triggers for giving this talk, not entirely helpful. We've got a broad collection of documents that address certain matters in certain ways. They never address everything. And we've also got a variety of documents by charities of varying assistance. Again, there's some that are very good, others less so, but there's nothing definitive. Now, partly because of the catchment of who we advise and when looking down the list of attendees, we've addressed both England and Wales, but that's also because we thought it was useful to, frankly, even Welsh guidance is probably going to be of assistance in England, even if you can't cite it for explaining a way forward and vice versa. So we didn't think there was necessarily a benefit in only looking at England and only looking at Wales. But what we've done here at this slide is try to summarise, and you'll see the teaser potentially in the last bullet point at the bottom of the slide as to where we're going on this, but try to summarise what the existing guidance that exists is and where to go within it to, as it were, get something of some use, and it varies. So we've got the guidance for local authorities on public rights of way, October 2016, from the Welsh Government. And there we've got this brief section dealing it between 226 to 230. And in particular, 229 talks about, it references the Fairfield Trust and the Pitcroft Trust. It references the British standard that we'll be familiar with for style, and I'm going to touch on, if we're not later, briefly, gaps, gates and styles. It references this least restrictive access policy I'm going to return to, but it's pretty brief, I must admit, between 2.26 and 2.30. We then, the next bullet point down, also from the Welsh Government, we've got this very, very particular guidance, statutory guidance for 147 and 147ZA as to having regard to the needs of people with mobility problems and authorising styles and gates. Again, not hugely helpful simply because it's incredibly specific. So probably quite helpful if you're looking at that very particular point, but of no use more widely than that. We've got Natural England have got a guidance note. We're now looking in England. We've got the Public Rights of Way Local Highway Authority responsibilities. And this sets out under sort of access and equality for disabled users, points about making improvements to public rights of way. I think Ruth is going to address whether it's quite right always to describe them as improvements, which is one of our potentially tricky issues that we've got. And it's got something on structures and policies, but again, not hugely helpful. And certainly the English Circular 1/09, pretty unhelpful, I'd say. It's paragraph 6.8 is where it deals with it, but it's dealing with the requirements of the Disability Discrimination Act 1995. So it predates the Equality Act 2010. So don't go, I'm afraid, to the circular for a huge amount of assistance. In our view, the best guidance document we've been able to find in our searches of it is the DEFRA's Authorising Structures, Gaps, Gates and Styles on Rights of Way Good Practice Guidance for Local Authorities on Compliance with the Equality Act 2010 guidance. Now, yes, it was published 14 and a half years ago. Yes, it seems to be in its title dealing with this particular point about gaps, gates and styles. However, actually, it is worth reading and having to hand in full because, first of all, it is obviously directly dealing with the Equality Act 2010 and published to help local authorities comply with it from a highway perspective when the Equality Act came out. In the annex, in particular, in the annexes, it actually goes beyond simply talking about gaps, gates and styles. It looks at and directly addresses issues and obligations arising from it over 35 pages. And it does a number of things that we think, again, some of these things I imagine won't be hugely come as a surprise, but we think is useful. It endorses this least restrictive principle, in particular for this issue of structures and points where it says the hierarchy should run. You should prefer the least restrictive structure, going from no structure all the way up to finally kissing gate if you must. It also references the forerunner, given it's been replaced now in 2018, of the British Standard for Gaps, Gates and Styles. Again, that is a useful document, a particularly technical document, but one which I'm sure many of you will be familiar with and worth, having regard to when you're doing it. But the reason why we place it as the best, in our view, is not just because it sort of is this useful discussion in the annexes of obligations and issues arising out of the Equality Act for highway authorities, but it, in a nutshell, boils down what we would say is the most useful and most important principle for highway authorities treating and approaching their obligations under the Equality Act, which is that it will never be binary, black and white, do this or do that. Never have a structure, always have a structure. It's got to be passable by people with mobility difficulties or it doesn't. It will always be a balancing exercise, and it provides and explains in a really quite eloquent way how to go about that balancing exercise. And what I've done here, again, and it's a text-heavy slide, but because I wanted to really have it in there, this is why we think at C5, and I think it's within the annex, in fact, it talks about these sort of different directions in which the tensions might pull and how you have to go about. And it's in the context of a structure, but we say actually this can apply more widely wherever you are asked to consider Equality Act issues. And in particular, what I really like, the line I like from this in particular, is the line that starts four lines down, where it says, the legislation on its own is not always going to assist an authority in deciding where its duties lie. Looking to the effect of a new limitation in the example would lead to the conclusion that the requirements of Section 20, due to make reasonable adjustments, are not met, and that it may make it impossible for a person to make use of the service. And note there, I do know interestingly, it's talking about it as being a service provider. We're not convinced on that, which is why we've dealt with it as a public function, but the points arise equally because of the limitation. Whereas as the rerouting of the way to an alignment that reduces the number of structures may make the route more accessible to other people with different problems, thus meeting the promotion of the equality requirements of Section 149. But in coming to a conclusion under these difficult circumstances, the authority will need to be able to show that it's made all reasonable efforts to understand where the balance of benefit lies, and that the scheme pursued, if it decides to proceed, contains the maximum benefits available, i.e., and it's really those last three lines, as well as the one about the legislation on its own. It's recognising this is going to be a difficult and tricky area for highway authorities. And it's recognising that there's no straightforward, simple answer in the legislation. But what it wants, and in mine and Ruth's view, the best shield that highway authorities can have in relation to this is being able to show that the highway authority have engaged and thought about this and looked at the competing tensions and then come to a conclusion, whatever it may be. But in understanding those tensions and carrying out that balance, and hopefully showing that the scheme, whatever choice you've made, contains the maximum benefits available. Of course, by the way, I should say that includes the benefit of for those who don't have a protected characteristic, because also for the public's right to pass and repass, and the benefit and joy coming out of the use of the public right of way. All of those will have to be fed into this. That's how we say, if there's one thing you take away from this talk, how highway authorities should start trying to consider these points. I think at this point in time, I'm going to hand over to Ruth to talk through 3 practical scenarios that we've come up with that may help to illustrate how the thought process, the balancing exercise that authorities have to go ahead when faced with these. Ruth.
Yes, welcome all, and thank you so much all for attending. There have been a few questions coming up which we will try to answer as we go through, and it may be after the event some of these questions will have to be answered. But what I'd like to do now, after Piers has gone through that very difficult part of the talk by dealing with all the complex law and guidance, I'd like to try and put it into practice by looking at some practical scenarios as to how you use that law and guidance in these various instances that we feel do arise in practice. So the 3 scenarios, the details are not that important in terms of 5-bar gate, footpath, etc. But scenario 1 is where you have a situation essentially where you have an existing obstruction over a public right of way, footpath, right of way, restricted byway, and that structure is causing an obstruction. The second scenario I want to look at is where one has a proposed new structure due to, for example, complaints of unauthorised vehicular use, I say of a footpath or of any public right of way. And then the third scenario, which has arisen in practice, is where a highway authority is threatened with a Section 56 notice, i.e. that a public right of way is out of repair, but on the ground that it can't be safely passed, I said by wheelchair users or indeed by any person with a protected characteristic. So if we turn to those in turn, because I'd like to look at what arises and how those instances can be successfully managed so as to comply with the Equality Act. Just 3 general points. These do very much arise from what Piers has already said, but firstly, to emphasise, every case will be fact specific. So one cannot give a list of what one must do and what the answer will be at the end of the day. It will be very specific to the nature of the public right of way, its location, the extent of its existing use, and of course the nature of the structure and the difficulties it causes. The second major point is that there will always be competing interests. We have the interests of those with protected characteristics under the Equality Act, but one has to also consider the interests of the landowner, which may be the reason why the structure has been put in place or wants to be a structure. There may be the interests of other public rights of way users, such as pedestrians and horse riders who do not want vehicular traffic to be using unlawfully the public right of way. And even the very character of the public right of way may be an issue. And the third point, which is worthy of stressing, although Piers has said it a few times, and quite rightly, what the public sector equality duty does is to require due regard to be had to those with interests to the interests of those with a protected characteristic. It is not saying what the outcome should be. It is the process by which one exercises that duty by having due regard, which will vary case by case, to those particular interests. So with that in mind, if I could then turn to scenario 1, which is where one has an existing structure causing an obstruction to a public right of way. Now, the first question in any such scenario is whether this structure is lawful or unlawful. If it is an unlawful structure, the position is pretty clear-cut. Then one has the situation where it is in fact a criminal offence under Section 137 of the Highways Act, obstruction of a highway. Will probably also be a public nuisance in civil law. In that scenario, there will also be the Section 130 duty on the local highway authority to assert and protect rights of all users of the public right of way and to ensure the removal of obstructions. So even aside from the Equality Act, a highway authority cannot just sit back and do nothing if there is an unauthorised structure on the highway. Some form of action must be taken. But in addition, one now has the implications of the Equality Act, and particularly in this scenario, the public sector equality duty, which would be engaged in determining what action to take. The highway authority will need to have due regard to those with protected characteristics. And just to emphasise also, those with protected characteristics are not merely those who are disabled. It will also include people who are, those with pregnant women. So pregnancy is a protected characteristic. Maternity is a protected characteristic. So those with parents with young children. The elderly, because age is a protected characteristic. So all those matters, where relevant in any individual case, will need to be had due regard to. So if it is unlawful, action has to be taken. The usual most common approach will be by the Highway Authority issuing a Section 143 notice under the Highways Act requiring the removal of the structure. If it's not duly removed, then the Highway Authority can act in default and the costs can be claimed from the landowner. And the other point to note in terms of an unlawful structure is there is also the remedy available to users or any other interested person who wants this structure removed because it's unauthorised. The Highway Authority doesn't take action. There is the process under Section 130A of the Highways Act onwards, very similar to the Section 56 notice to repair. But the Section 130A procedure enables the requirement for a highway authority to remove any unauthorised structure from a footpath or bridleway. So useful for that to be borne in mind. But then what about the position if the structure is lawful? And that can arise in a number of cases. Although it's an obstruction, it may be a lawful obstruction. It may be authorised. So, for example, the public right of way may have been dedicated subject to the obstruction, subject to the specific structure. It may have been authorised under an application under Section 147 of the Highways Act, which Piers referred to for agricultural purposes, to keep livestock in our specific land. So in those instances, if it is actually lawful, then the starting position is that the Highway Authority don't have any statutory power to require the removal of that structure. It is lawful, it's entitled to be there, it's authorised. So even though it may be causing extreme difficulties for those certain people with protected characteristics, that it cannot be required to be removed. Nonetheless, in that instance, and remembering the duty on highway authorities, or the duty under the Equality Act to make reasonable adjustments, and and it's important for highway authorities to remain proactive. Very important to note the power under Section 147ZA does confer a power on the authority to negotiate with landowners the removal or the alteration of any authorised structure. And that's a very important provision which authorities should actively apply in practice. I've referred to the importance of published policy, and this is referred to in the statutory code, which I also endorse people looking at. It's very, very comprehensive, and that emphasises the importance of an authority having approved policy dealing with authorised structures and how improvements will be made in practice. So it will be in a lot of authorities' rights of way improvement plans, for example, or it may be standalone, but to have that policy to set out what improvements will be attempted to be made, and then to seek to reach agreement with the landowners. The authority can agree to fund in part or in full those improvements, and if that agreement is reached, then the limitation on that public right-of-way would change to whatever has been agreed. So that making of incremental changes, improvements, is a means by which an authority can ensure that it's complying with its Equality Act obligations. And it's also important, though, to note, again, that in doing that, engaging, it's still important to bear in mind the needs of others, the other interests that may be conflicting. Don't just consider the Equality Act matters when one's dealing with these negotiations, but also the very purpose the structure is serving. And of course, if an agreement is reached, if the structure is changed in detail in terms of one goes from, say, a stile to a gate, which will be less restrictive, then in that scenario, there must then be a change and modification to the definitive statement, which can be done by a legal events modification order to reflect that change. And then the other point I make reference to, if in terms of an authorised structure, is a landowner still has a duty to maintain that structure. And so it is important for highway authorities to ensure that they do require compliance with that duty, to ensure that authorised structures are at the very least safe and properly maintained by making use of that provision. Finally, in terms of this first scenario, just a slight add-on to it, in terms of the creation of new rights of way, so be aware when there is, say, a Section 25 footpath creation agreement, or if there is a Section 119 diversion order being pursued, or if there's a new structure being requested to be approved under Section 147 of the Highways Act. In all those instances, it's important when considering the applicability of the Equality Act to try to negotiate the least restricted access, albeit, of course, taking all other interests into account. So again, by that means, the Highway Authority will be ensuring compliance with the Equality Act and taking due regard to the interests of those with protective characteristics. Also, when you're dealing with a new structure, approving a new structure or authorising a new structure on a diverted path or a new path, ensure that the appropriate standard of structure is being required. The compliance with the British standard should be ensured. That could go into the policy as well, that will be needed. Also ensure in as a term of the 147, as a condition of the 147 approval, or a term in the 119 order, for example, that when that structure is no longer required, when it's served its purpose and that purpose no longer exists, that it needs to be removed. And of course, always record any new limitations in the definitive statement. So that is kept up to date. And it would be helpful if it's as specific as possible, i.e. to refer to the nature of the structure, and indeed even the required standard would be of assistance going forward. If I could then turn to scenario 2, and this is now dealing with a position where there's no structure at the present time over a public right of way, or particular part of a public right of way, but there is a request for one. And the example we have come up with is one that does arise quite often in practice, namely a request for vehicular use to be prevented, or to be prevented from, say, a footpath or a bridleway, so where that vehicular use is being carried out unlawfully. So in that scenario, in order to prevent that use, then appropriate barriers would ideally need to be installed. But of course, that would well have implications on those who are disabled or have other protected characteristics. So what are the considerations? What should one think about in that scenario? So firstly, as I've mentioned on the slide, it is a criminal offence to drive on a footpath or bridleway under the Road Traffic Act. But note too immediately the tension that arises in this scenario between the Equality Act obligations, which clearly the authority has because of the new structure, but also there's then a separate duty on the higher authority under the Crime and Disorder Act to do all that the authority reasonably can to prevent crime and disorder, which would include antisocial behaviour. So there's a duty to try to seek to prevent this vehicular misuse, and there's an obvious tension that arises. The higher authority do have a power to erect barriers in that situation. They have a general power in Section 66 of the Highways Act. So what should they do? And essentially, in that situation, you're dealing with an instance that Piers referred to of indirect discrimination by the addition of a new structure, and you would also have the public sector equality duty being engaged. So in that situation, the starting point would have to be to collate all the evidence that's available to ascertain whether there is in fact a material problem at the present time. Higher authority doesn't want to be putting up a new obstruction, a new structure that would have implications for lawful users unless there is a real and justified reason for doing so. So the evidence of that is extremely important to collate and to have it in order to justify taking action. Also necessary to balance all interests. So you have the interests of those who have a protected characteristic. You've also got the interests of other pedestrians, other horse riders who are able-bodied, don't have a protected interest, and all people, all those users who don't want the danger of traffic using the public right of way. All that must be considered. And once that is done, if it is felt, going back to the reference to what Piers said, if it is felt there is that legitimate aim then to prevent the unlawful use of vehicular traffic, then by considering the least restrictive structure that would still achieve that aim, then that would ensure compliance with the Equality Act. But the evidence for that would be of vital importance and must be ensured in order that the Equality Act obligation is properly met. And then turning to scenario 3, so this now is the example where it has been raised in practice, where a Section 56 notice is sent to the authority. This is a notice that a highway, so dealing here with a public right-of-way form of highway, is out of repair. So it could be being suggested that because of the condition of the surface of the highway, because that's what we're dealing with here, the surface, it could be said that its condition is such that it is not safely passable by, for example, those with mobility problems, those with wheelchair users, etc. If they can't safely pass because of the condition of the surface, then there may be situations, or there have been situations, where a Section 56 notice is then issued on the highway authority to put that public right-of-way in repair. So, for example, a really muddy track that will be difficult for anyone with mobility issues or a wheelchair user to negotiate. Section 56 notice is linked with the Section 41 duty in the Highways Act for a highway authority to maintain the highway, to keep it in good repair. And the fundamental test in any of these cases is that on the screen from case law, that the public right-of-way must be kept in such good repair as renders it reasonably passable for the ordinary traffic of the neighbourhood at all seasons of the year without danger caused by its physical condition. So that's the test, and I'll look at how one would apply that in practice. But it is important to note that there's no requirement in that duty, and therefore in the Section 56 notice requirements, to improve the public right-of-way. So there's no requirement for a highway authority to start widening it to enable users to pass more easily, to change its topography, its alignment, or even to extent to change its surface, to resurface if it's always been an unsurfaced and unsealed surface. Those would amount to improvements which an authority has the power to do, but not a duty, and therefore they couldn't be required under a Section 56 notice. But going back then to the real issue, whether that fundamental test is met, the question would be, is it reasonably passable for the ordinary traffic of the neighbourhood? On that issue, one would have to identify what that ordinary traffic of the neighbourhood is. So in terms of those with protected characteristics, one would have to ask for that particular public right-of-way, could it be reasonably expected for it to be used by certain persons with protected characteristics? Are they the ordinary traffic of the neighbourhood in respect of this public right-of-way? So one would consider the nature of the public right-of-way, its location. Is it a rural path in the open countryside, miles from anywhere? What's its character? How does it link with the rest of the network? Or is it an urban footpath? Does it serve premises? Does it serve facilities? Is it means of access to schools, etc.? All those characteristics would have to be considered to ascertain what was the ordinary traffic of the neighbourhood. And of course, if it has previously been used by wheelchair or mobility scooter users, etc., and it has stopped being so used because of the condition of the surface, that would of course be clear evidence that it was out of repair. But otherwise, one would have to ascertain, the highway authority, what is that ordinary traffic of the neighbourhood for which this particular path needs to be made safe. And I do say that it's not the case that all public rights of way have to be made accessible by everybody in order to be regarded as being in repair. Otherwise, one would never have any muddy tracks in challenging conditions and challenging terrain, which of course many users do want. Paths of that nature. So it's important to ensure when dealing with a Section 56 notice that one is considering that particular public right of way, and by doing that one would ensure that again that the Equality Act duties are complied with. And then I just wanted to make a few final points, really just to bring all this together in terms of complying with the Equalities Act. I do emphasise that it is important for local higher authorities to have a published policy which is followed by them, probably in a rights of way improvement plan, and for that to contain all the issues over what improvements will be sought, what standards will be sought, what kind of conditions will be sought for new approvals, etc., and have that available and in the public domain. Secondly, I emphasise the position there that for all new structures that are authorised on public rights of way, always ensure that it's the least restrictive means of access, the least restrictive structure that will still meet the legitimate aim, but balancing all other interests. And in that way, one would ensure compliance with the 2010 Act. Useful to specify the standard, whether it's British standard, etc., to ensure the safety and proper convenience to the public of that particular structure. Require and enforce the maintenance of those structures to keep them safe. Require their removal in the terms of the order or the approval when it's no longer required, and record those structures in the definitive statement, which can be done then by a legal events modification order. So you don't have to go through a full process of a definitive modification order. It's the easier process because a legal event has occurred by the diversion, the approval, whatever. And then finally, I just do mention in terms of new developments, do remember in circumstances where you have a new development, both the highway authority and the developers can take advantage of any diversions that will be required as a result of that development. So there, the highway authority can negotiate an appropriate diverted route. It may have benefits by having less structures than the existing route. It can be better surface. It can be made more accessible if that is appropriate in the particular case, thereby ensuring again compliance with the Equality Act. And in terms of existing public rights of way, developers can seek to make improvements to existing ones, maybe by making the structures more accessible, less restrictive, and better surfacing, etc., to increase the merits of that particular development. So those are a few thoughts in order to ensure compliance with the Act. It's now 11 o'clock and there are so many questions that are thrown in.
What I thought I'd do, I've first of all seen there's been sort of fantastic discussion and debate through the webinar chat, and that's excellent. I think a sign that more usually we should get sort of highways and public rights of way officers together, because it leads to very interesting chats and questions. What we're going to do, or what I'm going to try and do in the sort of minute, is rather than the lots of discussion in the webinar chat, there were two, as it were, questions asked on the Q&A. And if I just try and deal with them briefly. Miranda asked in relation to whether we were just considering looking at this from the protected characteristic of disability. She says, what about protected characteristics of sex and indirect discrimination against women who are most of the horse riding community? So in terms of whether we focus just on disability, obviously we've touched upon that in particular because that is often where you get these tensions arising. But also, for example, in terms of the protected characteristic of pregnancy and maternity, that triggers a lot of the same issues. But to deal with particularly the indirect discrimination against women who are the most of the horse riding community, I think that's quite a useful illustration of how actually whether that would ever arise. Because, of course, if it's a bridle way, if horse riders have rights over the public right of way, then anyway, there are going to be all sorts of duties and requirements to protect that right on the highway authority, regardless of indirect discrimination. If you are putting it up an obstacle in a bridle way that prevents horse riding, well, then that's not going to be appropriate to do before you even get to indirect discrimination. Equally, if it is a footpath on which horse riders cannot ride, then if it is, I suppose, meets the definition of indirect discrimination, well, it's preventing horse riders is a proportionate means of achieving a legitimate aim because they can't lawfully use it. So I think in terms of the particular equality issues that may arise from horse riders, I think that's going to be often dealt with, in fact, through the requirement to protect rights of horse riders through other elements. And then just very briefly, because we're 1 minute past, I'm sure some of you are leaving already, Sue asked a really good question, and it highlights this tension between public function or service provider. There is no clear-cut answer. We think it's appropriate to look at it primarily from the context of of the highway authority providing a public function. Chapter 11, I should say, of the statutory code is where there's this useful distinction raised. But there will be an overlap. And in fact, on the discretionary power of an authority to make a diversion order, that could be an instance where it's moving a bit more towards a service provider. I'm still myself not convinced entirely, but I just thought I agree it's an entirely valid question. And I think our advice on a protective basis is it's going to be one or the other. So maybe it's worth considering both. I'll just give you this final point to you all. If it is being alleged that you're a service provider, I mentioned that Schedule 2, Paragraph 2, Subsection 8 talks about how if you're giving a public function, you don't need to do anything that you'd have no power to do. The equivalent for service provider is Paragraph 2 of Schedule 2, Subsection 7, and this is really important. It says that if you're a service provider, the duty to make reasonable adjustments doesn't require you to take a step which would fundamentally alter the nature of the service. I.e., if, let's say, a diversion order is a service, then nothing within the duty to make reasonable adjustments would require you to, as it were, fundamentally alter what you're doing, i.e. not make a diversion, etc. It is secondary to that fundamental nature. That's important to bear in mind. Well, thank you all. I think at points, I'm sure people are dropping off now, but at points, no, we were at over 300, getting close to 400 people for most of this. We hope you found it useful. It is an interesting, grey, tricky area. We will ensure that this is sent out along with the PowerPoints. But of course, if you have got any questions, queries, concerns, then that is what the King's Chambers Highway team is here for. And we'd hope to hear from you. So, Ruth, any final words of farewell? I should leave the last word to you. It being the newest.
There are still a few questions, but what I would just say, if anyone has any really burning questions they'd like us to answer within reason, please send them to the Highways team, Piers and I, and we'll try to pick some of them up because they are still coming through now, and there's some really good points. So please do email us. I will try and answer as many as we can. But thank you so much all for attending. It's been great to see so much interest.
I'm going to stop sharing and I'm going to try and end the webinar there. So thank you all. Thanks very much.